Good afternoon, everyone, and welcome to this joint committee session of Government Operations and Fiscal Policy and our Economic Development Committee. I am glad to be here and joined by the chair of the Economic Development Committee and the co-chair for this joint session. We have one item before us this afternoon, and that is Bill 22-25, Labor Peace Agreements, Hotel Development Projects. And I want to thank my colleagues, Councilmember Natalie Fanning-Gonzalez, Councilmember Katz, and myself. We're the three leads on this. And before I turn it over to Councilmember Fanning-Gonzalez, who really took the lead on it and did most of the heavy lifting on this bill, I just want to say thank you to Ms. Wellens for her work on this, and to say that this legislation really will benefit everyone here in Montgomery County. Our workers, our industry partners, it protects our local economy from disruptions. We know that labor peace agreements are not new. We have them in the county already for our trash collection contracts, and they are pretty much the norm in the region and across the country, especially when we are talking about the hospitality and tourism industry. In particular, this legislation is even more timely right now, given that the Trump administration is ignoring federal labor laws and eviscerating workers' rights. And so it makes it even more imperative that we take these steps here in Montgomery County. And now it is my pleasure to turn it over to my co-chair, Councilmember Fanning-Gonzalez.
Thank you so much, Madam President. I will just add one thing. This is also not new because there are jurisdictions across the U.S., including in D.C., and in Prince George's County, that have similar pieces of legislation. So we're not creating anything that is not happening somewhere else. So that's all. Thank you.
Great. Thank you. Councilmember Katz, as the other co-lead, would you like to say anything?
No, thank you all. I've said it all. Thank you very much.
Great. And I will mention that we are joined by Councilmember Lukey, as well as the two committees. Ms. Wellens, I will turn it over to you to walk us through the packet.
Great. Thank you, Madam Chair, and thank you, joint committee members. Bill 2225, Labor Peace Agreements, Hotel Development Projects. The basis or background for this bill is that, as you know, the county sometimes participates in development projects, specifically hotel projects, as a property owner, lessor, proprietor, lender, or guarantor. And in those cases, the county would face similar risks and liabilities as those faced by other businesses when the county is essentially acting like a business in a marketplace. And so the county in these situations has an ongoing stake in the financial success of the project. And so the purpose of the bill is to establish a general requirement that whenever the county has a proprietary interest in a development project, a hotel development project or conference center, that the employers at the project would be required to enter into labor peace agreements with the unions. The purpose of those agreements is to avoid strikes, lockouts, or other adverse economic actions that could affect the county's proprietary interests. As Chair Fanning-Gonzalez noted, other jurisdictions have similar laws, including Baltimore City, Prince George's County, and the District of Columbia. The bill before you, they're all rather similar to each other. The bill before you is kind of specifically modeled after Baltimore City, but shares a lot in common with the other two jurisdictions as well. There are a few issues for the Joint Committee's consideration. The first one, I think, is relatively easy, or straightforward, I should say. And this is on page 3 of the staff memorandum, and relates to the definition of hotel development project. And this is a clarification of the definition recommended by the Office of the County Attorney, and I think it makes sense and would hopefully bring more clarity to the language.
Great. Nope. Not seeing any objection. Continue.
Item number 2 relates to just an issue that the committee might want to consider, which is the level of discretion given to the chief administrative officer under the legislation. And apologies, I should have also recognized Mr. Hartman Espada here on behalf of the executive branch. Thank you for being here. So under the bill, the chief administrative officer would be the one responsible for determining when a proprietary interest is present. The main situations would be when the county is leasing its property for a hotel or conference center, where there's a management contract in which the county has a right to ongoing revenues from the project, tax increment financing situations, if the county was acting as a guarantor or underwriter. And then finally, you'll see that those are items, subparagraphs A through F, and A through E, excuse me. And then under F is a more general catch-all to in which the CAO could require these agreements in other situations in which the county has a significant and ongoing economic and non-regulatory interest. The county attorney's office did, note for the committee's attention that obviously that is a rather broad authority. I would note that it is present in the other jurisdictions that we mentioned. Prince George's, Baltimore, and District of Columbia do have that same catch-all, but I'm not personally sure. I don't know if Mr. Hartman-Espada has comments on it, but I'm not sure. I can't give you a good example of when it would be used, but obviously these deals are complex, and yeah, so that's a discussion point for you.
Great. But just to be clear, the county attorney's office is recommending we delete that paragraph. Is that correct?
They were really bringing it up as a point of consideration.
Okay.
Right.
Okay. Concerned about.
Right.
All right. Mr. Hartman-Espada, do you want to?
I have not had the benefit of a conversation with the county attorney about their opinion on the subparagraph, and I would have to defer until I do so.
Okay. Councilmember Fanny Gonzalez? Yeah.
Look, I think we mentioned this or talked about it before. It's in other laws in other places. I don't have a problem with it. They are not saying no. They're just flagging it. I'm not hearing a strong no, and they have time to give us more opinions. So I'm okay leaving it, but.
Yeah. Councilmember Friedson?
Yeah, I appreciate that. I mean, there is a little bit of uncertainty here of when it would be used, how it would be used. I think the goal here is clarity. I would personally be more comfortable if we struck it. I think that the goals of the legislation are covered pretty specifically in A through E. I have a refinement on that and an amendment that we'll take up after we get through the packet. But, it's not clear to me the problem that we're solving by adding that. And there are concerns about potential issues and lack of clarity that could be created by including it. And, I think the goal here is to be as clear as possible of what we're attempting to do and why we're doing it. I think it's easily understood in A through E. It's not so easily understood in F. So I would suggest that we strike it.
Okay. Yeah, Councilmember.
I'm not pushing back. I'm just saying that I'm okay deleting this if that brings everybody more comfortable.
All right. All right. So, Councilmember Friedson, do you want to make a motion to?
Yeah, I'll move to strike.
All right.
F.
We have a move to strike section F. Do I have a second? Second. Councilmember Balcom. Any other conversation on this? No. All those in favor of striking? Sorry. Yeah. Sorry.
No.
Okay. All right. All those. That's what we do here. All those in favor of striking subparagraph F, please raise your hand. And that is unanimous of the two joint committees.
I need people watching me at home.
Oh, we know.
Okay.
All right, Ms. Wallens, you can continue.
Thank you, Madam Chair. Issue number 3, which is on page 5 of the staff memorandum, is sort of the reverse almost of what you were just discussing. It also relates, this was also noted by the county attorney's office, and this also relates to the discretion of the chief administrative officer to determine when a labor peace agreement might not be appropriate for a particular project. And as the bill is currently drafted, the CAO would be required to determine that there is no proprietary interest, therefore no LPA is required, if the present value of the county's proprietary interest is less than $100,000. That's relatively straightforward, but then B is, or if the CAO determines the risks to the county's financial or other non-regulatory interest resulting from labor management conflict is so minimal or speculative that a labor peace agreement would not support the county's proprietary interests in the project. So obviously there's a standard established there, and you know, the CAO can exercise that standard, but it is, you know, does provide a lot of discretion.
Great. Anyone have any thoughts on removing that, keeping it in? Councilmember Sales?
On this section. Okay. So we're I wanted to ask about the for clarification. We're on the TIF. Are we on?
We are on the situations in which not necessarily the TIF, we're on any situation in which we're determining whether the county has the proprietary interest. Could include TIFs, yes.
Yep.
Yes. So I know that you said that we had Baltimore was the jurisdiction that inspired this legislation.
Primarily, the drafting was modeled after Baltimore City, yes.
Okay. Because I'm just thinking about when we compare Montgomery County, it's usually to Fairfax and other neighboring jurisdictions. And I'm just wondering if there was language in that version that we ensured was similar or replicable to this version.
Yes, this language is actually used throughout the other jurisdictions that we've mainly looked at, including Prince George's and District of Columbia, as well as the Baltimore City. That particular language is kind of, you know, consistent through those examples.
Are there any examples from Virginia that we referenced?
I did not, but I'm happy to, you know, provide
Okay,
you with
'cause
supplemental information. I believe in the testimony, I believe that there were references to labor peace agreements in certain development projects in Northern Virginia.
Yes. So that's what I'm wondering. We didn't have enough time to look at the labor peace agreements from neighboring jurisdictions that are more similar to Montgomery County. And so I just wanted to make sure, since we don't have that information, that I don't know how long it would take to review those LPAs from jurisdictions that we, compare ourselves to the most, to ensure that it includes as similar language as possible.
Right. Yeah. Again, this language is pretty much identical to Baltimore City, Prince George's.
Yeah, I know
and
what you're
District, but
referencing.
I'm
we
happy
don't-
to.
Yeah, I know. Just we don't compare ourselves to those jurisdictions. We talk about Fairfax, Virginia, and we talk about jurisdictions that, we're always saying Montgomery County is getting their lunch eaten by Virginia. And so if we are going to, put any sort of limitations or change how we are encouraging our businesses to operate in Montgomery County, especially the hospitality industry that's still reeling from the pandemic, I just want to ensure that we are still ensuring that we are just as competitive as our neighboring jurisdiction that's just as similar as we are. So I don't have the language. I don't have an example in front of me. I couldn't find one, and I'm just trying to figure out if there are examples of them.
I'm happy to more closely examine the laws of, Northern Virginia jurisdictions, in terms of the terms of their LPAs on specific projects. I'm happy to look for that as well. That might be a little less accessible. I don't know if those are posted. They might be subject to their equivalent of FOIA or whatever, but
if we can get it before it comes back before the full council, that would be helpful. And then I had a question, just for clarification. We have this TIF district that we just agreed to build, Viva White Oak, that if a hotel, I don't know if a hotel is being planned there, but if a hotel was built there after this community is opened, that doesn't use TIF funds to finance it, would it be subject to an LPA as well?
If it was not part of the TIF district, then no.
Well, no, it's going to be built in the TIF district, but it's not using TIF funds.
Mr. Hartman Espada, did you want to respond?
Sure, and thank you, Councilmember Sales, for the question. The TIF district, as envisioned for Viva White Oak, is intended to pay for infrastructure costs, for grading the site, for putting in the streets and the public infrastructure. It's not envisioned to contribute towards the construction of a hotel or conference center. So that's not part of what gets financed by the TIF. In other jurisdictions, they use TIFs in certain areas if they want to offset or build an amenity like a conference center. In this case, that's not envisioned at Viva White Oak as part of this TIF that's been proposed.
Okay, all right. And then, when did Baltimore pass their LPA legislation? It was before the pandemic.
Bear with me just a moment. This tells me that. I'm pretty sure it is pre-pandemic, but ordinance 07, I think, let me double check on that for you, Councilmember Sales. I apologize. I think that it was 2007.
Okay, all right. And I'm just wondering if we've seen any fiscal impacts, any economic impacts that we can anticipate in response to this. I know they've had it a lot longer, but I don't know how many new hotels have been built there since this was passed there. If that has prevented or impacted any new hotel developments there.
Yes, Councilmember Sales, and that is another thing we can get further information on. Unfortunately, the economic impact statement wasn't available at the time of this, but hopefully before any final vote, that impact statement would also be available.
Okay, good. And then, how would the proprietary interest, is it determined in Baltimore? Is it the 100,000 that was proposed here?
Oh, it's for Baltimore City. It's the 100,000, or this more discretionary determination of. You mean like when we don't have the interest? So in Baltimore City, they make the same determination. We don't have a proprietary interest if the present value is less than 100,000.
Okay.
Or if the city makes that same determination that the risks to the financial or other non-regulatory interests are minimal and speculative.
Okay.
And then Prince George's and District of Columbia have a $1 million threshold.
Okay.
And they in those cases, the county executive or the mayor respectively makes those determinations. In Baltimore City, under the law, the city quote unquote makes the determination. And I tried to find out but was unable to before this meeting of like exactly how they do that. I don't know if they do a resolution that's also signed by the mayor. I'm not sure exactly the mechanics of that.
Okay, because this is calling for just a unilateral decision by the CAO, and no one else makes this determination.
Right. It would be a determination by the CAO within the executive branch. Right.
Okay. And so how will the county ensure its discretion is applied consistently across projects? Will they come up with the framework, or would it just be the dollar amount?
It would be both. As it's currently drafted, it would be both the dollar amount, that's kind of the crystal clear criteria, and then the other determination would be much more nuanced and based on a case-by-case basis of what are the county's specific financial interests in Project A.
So would it be feasible to require the CAO to get the opinion of the county attorney, OMB, and finance before designating a facility?
Yes. Yeah. I mean, I would expect the executive branch to seek the county attorney's opinion, but I'm not sure that there's anywhere else in the law where we, require the county attorney to seek advice in certain situations. The county executive to seek legal advice in certain situations, but I don't think you're precluded from doing that.
Okay. And then do we know if businesses have raised any concerns about how this policy has been implemented or enforced in other jurisdictions?
I could look into that further. I haven't looked into, business community reaction in other jurisdictions, but happy to follow up.
Thank you.
That might also be part somewhat of the economic impact statement analysis.
Okay. Yes. And then my last question, are there any labor protections that are included in the LPA that are not included in this bill from other jurisdictions? Did we leave anything out, or?
I don't believe so, not that I've seen.
Okay. And then we're still waiting on Virginia, so we'll see. Okay.
Yeah. Right, and I'm going to turn to Councilmember Fanny Gonzalez and then Councilmember Balcom. And I just want to say that depending on the outcome of the joint committee session, because we are going on recess in August, this will not be taken up by the full council if it's recommended by this joint committee until September. So I believe there is enough time before it would come before full council to have additional information, which I know is available because we've looked at it, but I will turn it over to Councilmember Fanny Gonzalez.
Just very quickly, there are labor peace agreements in Virginia, including Tyson's. This is common. It's nothing new. Big hotels in Virginia, Fairfax have them. And at the end of the day, this is about providing protection, not just for the workers, but also for the hotel, because you don't want to have disruptions during the day with strikes and so on. So it's about having a common understanding. So I'm just going to leave it like that.
Councilmember Bethel.
So thank you. I just want to this specific issue that we started the conversation of on number 3B, page 5. So for me, unlike the one that we just deleted, which gave latitude to include a labor peace agreement, this provides latitude to not go forward with an LPA. And so I think that for me, this provides an opportunity for the CAO to look at the specific parameters of a project to say, even if it meets the threshold, and I know we're going to talk about that threshold, even if it meets the threshold, there are other factors that indicate that this should not have an LPA. So I'm fine with this language.
All right, not seeing any other objections or questions, I think we will keep this language in and move on to the next item.
Great, thank you. The final item noted in the staff packet, and we're on page 6, item number 4, the meaning of non-regulatory interest. And this was another amendment derived from comments by the Office of the County Attorney, because in one place where we mention non-regulatory interests under the bill, we include the clarification that an interest no interest is considered economic and non-regulatory if it arises from the exercise of regulatory or police powers, such as taxation, except for the TIFs, zoning, or the issuance of permits or licenses. And the second time we use non-regulatory interests, I did not include that clarification, that clarifying language. So this amendment would simply add that clarification to the second instance of the use of the term non-regulatory interest. I know it's a little bit of a mouthful, but it's kind of just an important distinction to show that we're doing this when we're an economic actor as opposed to the more typical government zoning regulatory actor.
Yeah. Councilmember Fanny Gonzalez.
I neglected to say that I asked the Office of the County Attorney to look into this whole thing too. And this is another very helpful flag from them that it makes sense. And I want to formally thank them for all their work. That's all. Thank you.
Thank you. All right, not seeing objection, we'll take that technical amendment.
Sorry, I had a
Councilmember
quick
Sales?
question about the minimal or speculative risk to the county's interests. Do we know how that CAO will define this and what safeguards will prevent the routine exemption of projects from LPA requirements?
Yeah, I mean, I think that's a great question. I do think it would have to be an analysis on a case-by-case basis, depending on the terms of the deal, so to speak. You know, if there might be a case where, well, even though we have a proprietary interest of X amount of dollars, we realize that in order to have a labor peace agreement on this particular project or to, you know, insist upon that, would end up costing the county more money than, you know, than our investment, and therefore doesn't make sense in that deal. So I think it would be, you know, relying on the CAO to use the good professional judgment and applying their criteria on a case-by-case basis.
Okay, we may need to have clarification on the definitions and some options, at least to get started on what that means. Thank you.
Okay. Councilmember Lass.
Thank you, Madam Chair. I appreciate all the conversations, and Ms. Wellens, thank you for all the information and work on this, in addition to the sponsors. I just want to pick up on the question that Councilmember Sales just asked, and I would like to ask the administration. I think it is helpful that Mr. Hartman kind of share what the executive branch's thoughts are, not on this, but I think the bigger picture that's being asked is about economic development in general. When a proposal should move forward using this this law, when it becomes law, all the other factors that go into economic development, and I should have said from the beginning, I am very comfortable with the decision being that of the CAO, which is a decision vis-a-vis the county executive ultimately. I'm very comfortable with that. But as the executive and CAO's designee for this conversation, can you just share how these conversations unfold, given all the variables?
Thank you, Councilmember Glass, for the questions. Starting from the framework that the county executive supports this legislation, working down to having this tool in place as you enter into future negotiations is very helpful to help define. All parties are aware when they enter into those negotiations what's coming, what it takes to do business with the county. That's, if we're looking forward, that's not an issue. We have right now we require all of our trash haulers to have labor peace agreements, and we have had trash haulers come in and appeal, say we feel we don't need that, and they presented their reasons. There has not been a single one that's been granted. We require LPAs across the board, but we still have a process for hearing the economic arguments. I can only speak for this administration. I can't speak in the future of any. I don't know how big or small these projects might be. The next big project that might have a hospitality component might be the sports complex. I don't know. I do know this will come up next time the conference center is renegotiated in 10 years. We're working now to bring parties together and are seeking a second meeting in August with labor and the operator. It's a complicated situation there because it's not cut and dry. The operator of the hotel is a separate long-term ground lease that started off without any of these requirements. And if the conference center goes LPA, then that affects the other side of the house and that other party who's involved. So this is a complicated situation that we're dealing with today. But looking forward, about the types, it's going to depend on the facility. It's going to depend on what, right now, I can't think of a project that might be coming down the line that this would apply to, but anything's possible. But again, knowing eyes wide open, if you're going to operate a facility for the county in hospitality, you're going to need an LPA. That solves a lot of problems up front.
Very helpful to hear your perspective of how you all operate and think about this, and to know that this is an item that will be part of negotiation as the county moves forward. And it is at the executive's discretion as part of that negotiation. Thank you.
Thank you. Councilmember Friedson.
Thanks. Appreciate all the work that has gone into this. I've been involved in a number of conversations. We're going to move forward with an amendment after we get through the packet. But while we're on this line of conversation, I did just want to ask, is it the county executive's position that the county executive and the executive branch currently lack the authority to do an LPA in a situation in which there is an operator that runs a county facility? That could be part of the negotiation? Is the county executive's position that he is prohibited from doing that?
We've been advised by the county attorney that we cannot require an LPA. Anything, you can have discussions, and we certainly did have long discussions on the conference center agreement on labor, and we included language where we would share the cost should employees organize at the facility. There hasn't been an organization attempt yet. There is a labor organization that's seeking to organize, which is a little different. But right now, we lack the authority to require an LPA.
Could you share with the council that legal determination? Because it seems odd to me. I mean, separate from this bill. I mean, I've heard this before, and I don't really understand it. And could you share with us if there are any other aspects of a negotiation the county executive is delegated, or the CAO is delegated in almost every circumstance to negotiate deals? And it seems odd to me that the specifics of those deals are legally prohibited unless the council has expressly prohibited them. It seems odd to me, as long as they're within the spirit of what the appropriation authority is or what the overall authority is, that something would not be allowed to be negotiated. That would be a standard that I am not aware of in any other circumstance that is news to me. And I think it would be helpful for us from a public policy making standpoint to understand what the county executive is prohibited from doing in negotiations.
So I appreciate that follow-up, Councilmember Friedson. And I don't want to disclose the back and forth negotiations in the agreement that we have. As I said, there's no mechanism for us to require an LPA, to mandate an LPA, until this bill passes.
Well, just to be clear, my view is the mechanism is the negotiation itself. That is literally what a negotiation is. And so it's odd to me, unless there was a law or some provision of a law that inhibits the authority of the executive or his designee from adding an aspect to a negotiation. For instance, that agreement probably has a number of other things. I don't believe that we have legally provided the authority specifically to require certain things that you're negotiating. If we did, by definition, to be honest with you, there wouldn't be a negotiation, because we would have required every aspect of each part of the contract. And then we would be in a situation where the county council issues contracts, which, as far as I can tell, is not how we run county government. So I'm happy to move forward with this legislation. I think we've gotten to a good place. We're going to take up additional amendment to make sure that we're focusing in on what we intend to focus in on. I think we've given the appropriate level of discretion and clarity in the other conversations that we've had. But this dynamic feels a lot more like passing the buck than it does on a serious public policy determination that the county executive and the CAO lack the authority to negotiate certain aspects of contracts. It seems odd to me. And in the future, it would be helpful if the county executive wants to do something and feels like he lacks the authority to do it. It would seem appropriate at that time to communicate with the county council to request that authority. That didn't happen here. So since we're going down this path of what can and can't be done and what authority exists and doesn't exist, it would be helpful to understand what authority actually does exist and doesn't exist. And in the future, it would be helpful to understand if the county executive is looking to do something that he believes is in the best interest of county government and most importantly in the best interest of county residents, then he should request that authority from the county council.
So I appreciate that, Mr. Friedson. And I brought with me the 5 pages of gating items that we went through with Marriott from September 25th, 2024. There were multiple sessions.
Mr. Hartman,
it was a complicated negotiation.
I understand, but I
understand.
actually do not want this committee to get into the negotiations with Marriott. I appreciate that. And
the allegation was made.
I don't think an allegation was made. I think there was
failed to do something.
Well, I think there was a request for clarification because what the county executive has said in public is that he did not negotiate an LPA with Marriott because he did not have the authority to do so. You have just reiterated that and said that during the negotiations, which none of us knew were happening at that time, that the county attorney told the county executive he did not have that authority to require that in the negotiations. Fine. What we are asking for as a body is the legal opinion from the county executive's office to understand what the legal underpinnings there are for that, to say that the county executive did not have the authority to require an LPA, and if there are other things that in the county attorney's opinion that the executive office does not have the authority to negotiate, that would need formal direction from this body for policy in which to then negotiate a contract. Because I think this is very important. We did not know this contract was being negotiated because we are not party to that. That is the role for the county executive's office. We were informed after the fact of all of this. And in fact, I'm going to say, kind of thrown under the bus by the county executive, quite frankly. It's hard to act on something when you don't know about it. And so I would like to avoid that in the future. Because quite frankly, I think it puts this body, it puts our businesses and our residents in a very bad position. So the request here is for the legal advice from the county attorney's office so that this situation is avoided in the future. Now I want to get back to the bill that we have at hand. Ms. Wellens, is there anything else in the packet before we turn to the amendment that was passed out?
We've completed all the items in the packet. Thank you.
Thank you, Ms. Wellens. Next, colleagues, I'd like to turn your attention to 2-3 amendments that myself and Councilmember Friedson have been working on, and I will let Councilmember Friedson walk us through it.
Yeah, appreciate that. Thank you for your comments just now, and I appreciate that. Yeah, I really appreciate your partnership as chair and council president and one of the lead sponsors. Really appreciate the conversations that we've been able to have with the stakeholders as well as with the other lead sponsors and for their support and the interest in trying to hone in on exactly what we're trying to focus in on and address some of the concerns that were raised about the broadness of some of the language. We've already done some of that earlier to focus, and this would allow us to do that additionally. So there's really 2 parts, although one of the first part is in 2 places, and I have distributed this to colleagues. But this would amend lines 85 to 99 to change the term ongoing revenue and replace it with operating profit based on the financial performance of the project. That would be in both Part A and Part B. So that is Part 1, and then I can explain together, and we can take them up together or separately if you so choose. But we heard earlier in terms of the threshold number, the 100,000. Many other jurisdictions use the $1 million threshold number. We thought this was a more appropriate one. There's also a number of examples in state law where that's the trigger for this type of question in terms of proprietary interest. And so changing 100,000 to 1 million annually, which is amending lines 119 to 127. So I want to put those forward as a block if that is appropriate and agreed upon by the committee or joint committee here.
Sure, sounds good.
Second.
Second, Councilmember Nathan Gonzalez seconded. Any comments or questions on this? All those in favor of the amendments, please raise your hand. Okay, thank you, Councilmember Katz. Just so there's no confusion, that is unanimous. All right, Ms. Wellens, unless there's anything else anyone on the joint committees would like to take up. Not seeing anything. All right, Councilmember Lukey, you have anything for us?
No,
All right.
just was lurking here in case there was drafting issues, but we're good.
We have a bill that has been amended. All those in favor on the joint committee in recommending this for the full council, please raise your hand. And that is unanimous of the joint committee. All right. Thank you, Ms. Wellens. Thank you, Mr. Hartman-Espada. Thank you, everyone who joined us today. This joint committee of the Economic Development and Government Operations Committee is adjourned. Thank you.
We gotta wait until 3 p.m. for the next one.